Good morning, everyone. Mr. Moody, can you see and hear me?
Yes, I can. Can you hear me?
Good morning. Yes, I can. Good morning, Ms. Pedro. Can you see and hear me?
Yes, I can.
Okay, good morning. So this is the Court of Appeals in Bermuda today, Tuesday. Apologies.
The president's camera is off, I think.
So Christopher? Ah, there you go. So Christopher, your camera needs to be switched
I
on.
know, I'm clicking start video.
Ah, well, there you go.
All
right. This is the Court of Appeals sitting on Tuesday, the 22nd of June, 2021, for an application to Her Majesty and Counsel by Ms. Wanda and Pedro against the Attorney General and Minister for Legal Affairs and Constitutional Reform. These proceedings are taken before my Lord the President, Sir Christopher Clark, and Justices of Appeal, Dame Elizabeth Gloucester and Anthony Smelly.
Good morning, everybody. I'm sorry there's been a slight delay. We have been discussing matters between ourselves in our different time zones. We've read the submissions and the notices of appeal and the like. And it seems to us that there are, for present purposes, a tightly confined set of issues that we have to decide. The first is whether or not Ms. Pedro enjoys an appeal as of right to the Privy Council. The second is, and that is ancillary to the first, whether the proposed appeal raises a genuinely disputable issue. And the third is whether or not, if she is entitled to appeal, we should impose, what conditions we should impose, including the mandatory condition as to security for the appeal. And the last issue is whether, if she does not enjoy a right to appeal, whether this is a case in which we should give leave to appeal upon the basis that the question involved is one of general public importance, or otherwise ought to be submitted to the Privy Council. Now, we think that those matters ought to be dealt with, be capable of being dealt with in a relatively short period of time, and we have it in mind that the parties should spend about half an hour each, or up to half an hour each, in dealing with those issues. And because Ms. Pedro is the would-be appellant, I think it's for her to start.
Thank you. I did get an email from Mr. Moody just now, and it seems that Mr. Moody has stated in his submissions, which he seems to have quite a habit to do, really, is say things that are not true. So he states that, you know, the appellant gave additional new information, which isn't true, and I highlighted that in my submissions. Again, he sent an email just now stating that I did not claim anything in my original claim for under the Constitution, which isn't true neither, because I've now forwarded that email a few moments ago, highlighting the section where I did mentioned that my constitutional rights had been violated because I had been denied a fair trial. Having said that, there's also the argument that I was not present when Cameron Hill represented me, and God knows where misfeasance in public office came from, but obviously I wasn't present to hear that and only heard it after, which is why I obviously filed, my complaint to the courts, making my thoughts known that I was not happy that he had misrepresented my claim and my desire to sue the government for fraud and concealment. In my book, in my mind, that is all that I see that has happened here, that the miscarriage of justice has happened because they concealed evidence from me and denied me a fair trial, which resulted in my son being taken from me. And, that did violate my constitutional right to have a fair trial without witnesses, without evidence, et cetera, et cetera. But Cameron Hill somehow arrived at misfeasance in public office, God knows how. And I'm not saying that isn't maybe a component, but I think the crux of my case is fraud and concealment. And then Simone, in coming in at the last minute, I guess tried to carry on that argument for some reason. And I think with all the lockdown in England, as I stated, it made it difficult to convey, the depth of my case to her without being able to send her the insurmountable evidence that I have. And I've uploaded quite a bit onto the court portal now. Obviously, there's hundreds of pages more of evidence of social workers' reports and affidavits, et cetera, et cetera. So I do think, I don't know if I'm answering your question, because obviously I'm not a lawyer. I'm just a mother trying to fight for her child's rights. At the end of the day, this appears to everyone like this is my application, but I would not be doing this if it weren't for that my son is still suffering today. Because if he was fine, I'd be fine. And as long as my child is suffering, I'm going to suffer.
Can I try and help you, Ms. Pedro, as to what the issues for us are? There's an act called the Appeals Act, which gives the potential of an appeal from the Court of Appeal, which is us, to the Privy Council, in a number of limited circumstances. One of those circumstances is whether there is a final judgment of the Court of Appeal where the matter in dispute is of the value of $12,000 or more, and where the appeal involves, or where the appeal involves some civil right which amounts to the value of $12,000 or upwards.
Yeah, I'm aware of that. I'm aware of that section now. And the last part being of public importance. And I believe
No, I'm sorry. No, I'm afraid you're confusing two different matters. The section has two relevant subsections.
Mm-hmm.
The first subsection gives an appellant an appeal as of right, subject to a point I'll mention in a moment, when the matter in dispute is of the value of $12,000 or more, or where the appeal involves some civil right amounting to the value of $12,000 or more. That's That's circumstance number one. Circumstance number two, for present purposes, is that there's an appeal at the discretion of the court. That's to say, if we decide to allow you to appeal from a judgment which, by reason of its general or public importance or otherwise, ought to go to the Privy Council. Now, those are two different sections, and we have to deal with them separately. If you have an appeal as of right, then we don't have to exercise any form of discretion, though for that purpose, there's authority which shows that there has to be a genuinely disputable issue. So that's as it were, the first set of questions. If the position is that you don't have an appeal as of right, we would have to decide whether the case was of such public importance that it ought to go to the Privy Council. And obviously, if it didn't raise a genuinely disputable issue, it plainly shouldn't go. So we have to look at those two things separately. Do you follow?
I'm sorry, what section of that is that, so I could just have it in front of me?
The Appeals Act 1911.
Yeah, section.
Section 2A.
I don't know, I might not have the right one up, I think. Anyway. So you want me to answer to the part about it amounting to 12,000 or above for a civil right?
Yes.
Right. So, well, first of all, could I say that Mr. Moody never pleaded limitations. So I think the very beginning of the whole case has now become so convoluted with Miss Wheatley deciding her judgment mostly on limitations, and then the Court of Appeal carrying that on, despite
forgive me. You've made the point that limitation wasn't pleaded as such.
No.
On very many occasions, we followed that, but
Yeah.
that's a different point.
Yes,
The
it is.
first- Yeah,
So
well, can we-
I'm saying,
Sorry, can we-
yeah, so I want to say
Do
that
one
to
point
say,
at a time.
right, so I was trying to say that to say that had that not happened and a more experienced judge had presided then in 2019, we may not be here where we are today, because we would have probably had a trial, because a judge would have known what they were really doing and would have known that Mr. Moody did not plead limitations, therefore he cannot argue it. So then the case would have proceeded on my application, which was, yes, maybe prolix, and maybe it needed to be amended to read more fluently for you. But my point is that we wouldn't be where we are today, 2 years later, fighting the strikeout application, if Ms. Wheatley had done the right thing back then, which was allow the case to go through due process and have a fair trial. To this day, 13 years.
Ms. Pedro, I can assure you we have understood that point. But you're not, just a moment, do let me finish before you interrupt. You are not dealing with the point that I was asking you to consider. The first question, I think I know, just let me finish. The first question, I think I know what your answer is whether or not this involves some civil right amounting to the value of $12,000 or upward.
It does, because it originally did, but I don't know what it is today. That's the point I'm trying to make. I'm confused what my case is now. I know what it was. I don't know what it is today. That's the problem. That's the problem. Because Cameron Hill has thrown in his wrench. Simone was asked to do the impossible. and the Court of Appeal has written a judgment based on God knows what evidence. So my point is, it's kind of hard to answer a question when the cart has come before the horse. There has been no evidence laid by me. There has been no witnesses testified for me. You have built a one-sided judgment once again against me. And now you want me to answer. I get the point. I can answer that. It's easy. Yes, 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 and yes. It's over 12,000. It feels like a civil right to allow me the chance to lay my grievance before a competent court. You know, I mean, as I said, this wouldn't even be happening if Michael wasn't weighing 98 pounds with all of his bones sticking through. I'd be fine if Michael was fine, but Michael's not fine.
Right. Your case is that you have a claim which is worth, however it's put, is worth over $12,000. Right.
You know, it's for me, and I want to make this clear to the courts, right? Whether I succeed in this, which hopefully I am, and there is compensation paid, that is not for me. That is for my son. I want Michael provided for.
Right. Secondly, we have, on the assumption that your claim, if valid, is for over $12,000, and you originally put it at $250,000.
Yeah, well, I had 250,000. I think Cameron changed it to $1 million.
Well, never mind.
Right.
It's a which the next thing that we may have to decide is whether or not, at the stage which we have now reached, there can be said to be a genuinely disputable issue. Now, what would you like to say in relation to that?
Only that that it is obvious that Michael is the one that has suffered greatly through this. And as a mother, you know, just a mother who, you know, loves her child, I want to see Michael straight. I want to see Michael healed. I want to see Michael able to stand on his own 2 feet, because like right now, this world will chew Michael up and he'll be dead in no time when he's ready to go out on his own. My duty as Michael's mother, whether I raised him or not, thanks to Bermuda, I didn't get the chance. He will not stand on his own. He is weak. I don't even know my son. Okay. So, you know, it's just my duty as Michael's mother to see this through. And I just don't know what has happened to the claim. I just don't know what Cameron did. I don't understand what the Court of Appeal expected from Simone in this short space of time. I don't know how it got to this point.
The position that was left with her was that we had decided that in order to give you a fair chance to have the totality of your case in its final form put before the court,
Yes.
we should allow you to produce a draft written statement of claim which set out what that case was.
Mm-hmm.
That was intended to be helpful to you.
Right, but it actually turned out to be very damaging because England was in a lockdown. And Simone was given a very short space. This case is huge. This case is massive. There's papers in a suitcase. You know, I mean, like when I read it, it took me ages to read. And that's why I can't even figure out why one would say, I came back to bury my father in October of 2016. I came back to England. I created my website. I saw the European Union reading it and blah, blah, blah. And that's when I was like, oh, who's the European Union? You know, and I Googled who they were and I found out they were human rights, you know, courts advocates and whatnot. I was like, oh, human rights, what's that? And I started reading the articles, and that is what prompted me to have the courage to pull the file out that I had brought back with me and read what was in there, because it was my, desire at that point. I had been given some kind of hope that, okay, maybe I lost Michael on whatever grounds, civil, whatever. But here I might have a human rights case. So that's what led me to my journey to reading the file, then rereading, picking out so I became like a little investigator, highlighting the discrepancies in the reports, et cetera. And then I started to see the picture of what happened. And then I started to write my statement. And then I started to create it was a lot of work.
You're not actually, I don't think this is helping either you or us. We know the history of what you're describing, but we have to ask ourselves a number of specific questions. And I'm trying to identify the questions that we have to ask ourselves in order to enable you to say anything additional to what you have already said relating to them. And where we got to is that I had said that we have to determine whether or not, in the light of the judgment that we have given, there remains a genuinely disputable issue. Now, is there anything more that you wish to say about that question?
Well, I mean, the problem with all of that is you haven't seen my case. You're asking, how can I, if Wheatley had never done what she did, you would have all of that evidence in front of you and be deciding that question on paper, because you'd see the evidence, you'd see what happened. You're asking me to, in a sense, argue my case. I mean, it's really quite difficult, how this is all panned out, I feel like I'm fighting the system rather than fighting for my son.
Right.
I just want to fight for Michael. All I want is a chance to lay my evidence before the judges and allow you to decide from the evidence. You can't look at their evidence and say that's the evidence, because you don't have my evidence. How do I know they didn't orchestrate evidence that you've read? How do I know that it lines up with what I have? I have papers with signatures on them. I didn't sign them. They're all signed by the social workers, by the judges, etc. Why won't the courts allow me to lay my case before the court and just allow a fair trial to happen, due process?
It was precisely for that purpose that we allowed you unusually to produce, as indeed was produced, a very substantial draft statement of claim to set out the facts and legal propositions that you sought to rely on in order to make a case.
Right, but the problem with that was it was during a lockdown and Simone struggled to actually understand the magnitude of my case.
Well, there was a 2-month interval and she asked for a 28-day extension and for no further extension.
Well, I don't know. When did the letter come? In November? And then she submitted this on the 15th of December?
Mm-hmm. So she had about 2 months. Right. Well, the next item that we have...
during a lockdown, so yeah.
Well, we're working in a lockdown now.
Yes, but in England, lockdown was everything, including libraries and offices. Like, people were not able to go. I couldn't take my whole suitcase somewhere and say, excuse me, can I, scan and copy these to my lawyer?
Right. Now, the next question that we may have to determine is whether or not that the question involved in any appeal to the Privy Council is one of such general or public importance or otherwise that it ought to go to the highest court in the system. Is there anything that you wish to say to us in relation to that point?
Well, yes, because it's clear that social workers orchestrated. I mean, it's really quite shocking. It's almost hard to really explain. It's really out of this world. I still can't believe it. I'm still in shock that 13 years later, I don't have my son here caring for my son. It's still quite a shock to me. but it is clear that the social workers conspired with my son's father because he did have a sort of friendship with them, because he always threatened me that he will file a complaint to the department if I don't, do this or I don't do that. He was a control freak, and any threat that I was going to leave him, he would threaten me, with these, allegations that he will make against me, right? But I've raised 2 other kids other than Michael without any complaints. My children are well-rounded. My daughter's graduating from Birmingham University with her master's. Aaron's doing well as well. I mean, they knew that I did not cause my son. They knew that I did not cause my son any harm, okay? They knew. They knew. Because they would not have left my 12-year-old daughter in my care if they had evidence. They would have prosecuted me if they had the evidence. But they knew just taking Michael was enough to shatter my home and my life. But they didn't even care that it was causing Michael serious damage, that I had to watch my son falling to his demise.
The test is one of whether the question involved in any appeal is of great general or public importance.
Well, it is, because the general public need to know that, this department deliberately took part in a personal vendetta against me. They knew what they were doing and what they were writing was unsupported, because they never even questioned my daughter. They never questioned my other son. They never questioned my aunt, who I was very, very close to. None of Michelle's teachers. I mean, my children had outstanding report cards, outstanding citizenship. They were role models. How is it that Michael plummeted so quickly? That was just heart-wrenching to watch, and that is what caused me to keep fighting and fighting and filing and filing. No matter where I was on the planet, I would have continued to fight for my son. And it was really ultimately that 2013 application that I think severed, and really at Michael's age, 13, and, he became aware that I can't help him. I can't rescue him from this.
Right. The next question that we may have to determine is this: if leave to appeal to the Privy Council is granted, it is to be on condition that the appellant, that will be you, within a specified period of time, not exceeding 3 months, provides security in a sum not exceeding $12,000 for
Right,
the
I've
due
spoken.
for the due. Can you not interrupt me? For the due prosecution of the appeal. Is there anything you wish to say about that?
Yeah, I spoke to the Privy Council about that, and they said that I just need to submit my benefit letter showing that how long I've been on it and that I am on the benefit because of my neck injury, and that that could be waived. So I've provided that.
Do you have any savings, Miss Pedro?
No, I don't.
Thank you.
Right. Not absolutely sure the Privy Council deals with this aspect of the matter as opposed to the costs in front of it, but we may have to look up on that. Right. Well, those are the matters that we need to consider. Is there anything else that you would like to add?
Right. Well, no, just, that Mr. Moody did not plead limitations, but you're aware of that, in his defense, and strikeout filed without an affidavit. And obviously, Miss Wheatley and I had quite a few contentious conversations prior to the hearing, which, I had at that point requested her not to preside because I didn't think she would be able to be unbiased, but that fell on deaf ears. The whole thing just seems like one big circus. People turn to the courts for justice. They don't turn to the courts for chaos and more injustices. They turn to the courts because they really genuinely want justice, and especially when you're innocent. That is just mind-boggling if an innocent person cannot obtain justice through the courts. That just completely is mind-boggling and very worrying. Very, very.
Right. Thank you very much. Right. Mr. Moody, what have you got to say?
If it pleases you, my lord, my lady, I think I will try to directly answer the relevant parts in my submission of what Ms. Pedro just said. The evidence, firstly, we say under the first limb of the Appeal Act that the Crown does not believe that this matter fits into the category of matters valued over $12,000. We say this because in our humble submission, the claim was misconceived from the very outset. Hence, the strikeout application was made, and the ruling by the court, by Ms. Wheatley, was to strike out the matter because it was frivolous, vexatious, and abusive process, because one, the appellant consented to the very orders she complained of, and two, the matter was statute barred. So, to answer the question specifically, the evidence on which the Crown relies to say that there is no genuinely disputable evidence is the record of the court, and that's reflected in paragraphs 12 and 13 of the Court of Appeal judgment. Specifically, and I'm reading from paragraph 12, where the court makes reference to the orders made in the magistrate's court. The last three of these orders, those rendered respectively on the 29th October 2009, 3rd November 2009, and 8th January 2010, are all expressed as made with her consent. In paragraph 13, the record of the court, which the Court of Appeal has reproduced, indicates the following order, and that was an order made on 8th January 2010. That Miss Wanda Pedro states that in the interest and welfare of Michael Jones Jr., she wishes to withdraw her application for custody, care, and control of Michael Jones Jr. And in this regard, the court orders that her application is hereby withdrawn. 2, that by consent between the parties, Mr. Michael Jones Sr. and Miss Wanda Pedro shall have joint custody of Michael Jones Jr. 3, that by consent, Mr. Michael Jones Jr. shall continue to have care and control of Michael Jones Jr. And with this regard, Michael Jones Jr. shall reside with Mr. Jones. Those are the reasons, and that is the evidence, we say, demonstrates that effectively there is no genuinely disputable issue. These orders were never appealed. And the claim in respect of Ms. Pedro was made over 8 years after these orders were made by the court. The court has already considered and I would say dismissed her arguments in favor of why the Limitation Act should not apply. And therefore, we believe that, certainly in terms of the first limb under the Appeals Act, this matter does not fall to be considered therein.
Well, just to say, yes, can we take it in the proverbial stages? If the position was that there was a well-founded claim in the sense that what was asserted amounted to a cause of action, we would be in a situation, would we not, that there was a final judgment of this court where the matter in dispute was some civil right worth more than $12,000.
We would have to concede that position, that if it was properly pleaded, the value of her claim as she asserted it certainly would have been over $12,000. But I think there is the second limb to that, which concerns the court's discretion, even if she has an appeal as of right, to determine whether there's a genuinely disputable issue. And so we say in that regard, the court still should not, under this section, grant leave to appeal.
So that's relying upon the Privy Council's decision in the case whose name I always forget, from Guernsey.
Yes, in fact, I just briefly read that when it was sent around, and that really underscores the position of the Crown in this matter.
Yeah.
That an appeal would essentially be futile.
Mhm.
Right.
Because of the evidence that I think this court has appreciated, and it's reflected in paragraphs 12 and 13 of its judgment.
What evidence? What evidence?
Please do not interrupt, Ms. Pedro. You will have a right of reply.
Oh, thank you. Okay.
Assume that if you're right on that, you're right on that. If you're wrong on that, well, if you're, sorry, start again. If you're right on section 2A, we would still have to consider 2C, which is whether or not the question involved in any appeal is one of great general or public importance, or such as otherwise should be submitted to Her Majesty. What do you have to say in relation to that?
Lord, I think I've cited the Siddiqui case, which I uploaded to the cloud. And I think there is a paragraph that I would like to refer this court to, which underscores the Crown's position in this case. And
Yes.
that is paragraph 54, where the court cited the dictum from a judgment of 2018 in the BVI Court of Appeal of Renaissance Ventures against Komodo Holdings. The court found it particularly instructive. And I will quote, "Where there is no dispute on the applicable principles of law underlying the question which the appellant wishes to pursue on his or her proposed appeal, a question of great general or public importance does not ordinarily arise, especially where the principle of law is settled either by the highest appellant court or by longevity of application. Where the principle is one established by this court, but is either unsettled in the sense that there are differing views or conflicting dicta, or there is some genuine uncertainty surrounding the principle itself, or it is considered to be far-reaching in its effect, or given to harsh consequences of force or for some other good reason would benefit from consideration at the final appellate level, this court would be minded to seek guidance of their lordship's board. Where, however, the real question on the proposed appeal is the way this court has applied settled and clear law to the particular facts of the case, or whether judicial discretion was poorly exercised, leave will not ordinarily be granted on this ground. In such a case, the question on the proposed appeal may be of great importance to the aggrieved applicant, but it would not for that reason alone be a question of great general or public importance. We say, my lord and my lady, that the principles elucidated by the Court of Appeal in its judgment reflect settled law in all aspects, whether it be the de facto principle, which we say has existed from the Margaret Court case, which is of some antiquity, to the basis of the court's discretion on a strikeout application, how it should be applied, to the fact that this court found that the pleadings have to establish categorically, especially in cases where misfeasance is being argued, that there was some malintent, some bad intent. And we say none of that was established in this case. So certainly we would say that the dicta of the court in the Siddiqui case would suggest that this matter ought not to be granted leave under ground C of the 1911 Appeals Act.
Now, if we're with you on those points, the next one doesn't arise. But if we were against you on those points, we would have to consider the conditions upon which leave to appeal might be granted. Do you have anything to say in relation to that point?
I think, my lord, that the history of this matter is quite important. Ms. Pedro appeared as litigant in person initially. She was represented by counsel. When she appealed, we did not ask for security of costs, as we could have done, to the Court of Appeal. The Court of Appeal, in its discretion, because she was legally aided, did not award costs when it delivered judgment in favor of the Crown. But this matter, as the court has seen, has been in the system, so to speak, since 2018. It has commanded quite considerable resources for the Crown, resources which could otherwise be directed, and has directed the attention of, I would say, more than one counsel, certainly in reviewing the matter, and the extent of the matter, especially as it became more complex as we went through the appeal process. Particularly because we say there is no genuinely disputable issue, and in recognition that there would be a cost to the Crown to contest this matter before the Privy Council. We would have to instruct counsel in London, etc. I think there is a real risk here that, the government again would be found, I would say, out of pocket, because while we don't bill for costs, there is an actual cost to hiring counsel, to staffing chambers. I think it would only be fair in the circumstances for the court to exercise its discretion to ask for some security. The amount of security is certainly within the discretion of the court. I have not seen the document that Ms. Pedro has referred to, which is her letter of benefits, which she allegedly submitted directly to the Privy Council. I haven't seen that. I don't think it has been submitted to this court.
It's uploaded, yeah.
Sorry, I haven't seen it yet. But I think in the round, when one considers the futility, as we submit, of the appeal, that this court should exercise its discretion to award costs. It could do so in a relatively nominal figure if it felt appropriate. And given the assertion by Ms. Pedro that she will be representing herself, even at that level, I think the court could exercise its discretion to order a conservative sum if it is so minded.
Right. Thank you very much. Is there anything more that you would wish to say to us?
I think we've covered all the issues, unless there are any questions for you.
Well, there are
From
none
you.
for me. I don't know whether any of my colleagues have a question.
And from me, thank you.
No. Right. Ms. Pedro, you now have a right of reply.
Thank you. Mr. Moody stated that I consented to the order in 2010, in 2009, whatever. But specifically the 2010 one, where you also say in your judgment that I did. But I want to point out that in the transcripts of Ms. Wheatley's hearing that we had in Supreme Court,
Yes.
Ms. Wheatley asked me directly, did I or did I not consent to any of the orders? And I specifically told her that I had not, which I know that you saw because you actually said to Mr. Moody in the hearing that when he said that I had, you said, well, that's not what the transcripts say. And for some reason, I can't put my hands on it right now. I had it just now. But Ms. Wheatley asked that, but yet in her judgment, here it is right here. She says, did you or did you not consent to these supervision orders being put into place? I answered, no, I didn't. Obviously, I didn't. Further down, I was never in agreement with anything. That was the whole reason that I fought for 2 years for my son. And that was whilst in Bermuda. So I clearly told her that. So I want to say in her judgment, she then writes her judgment saying that I told her in the hearing that I agreed and consented to these orders. She states in paragraph 19 that it was admitted by the plaintiff that she consented to the supervision orders, but I didn't tell her that, and it can be heard in the court recording that I did not consent. In paragraph 20, she says, well, it wouldn't have been expected given Ms. Pedro's consent to the applications. And then somewhere else she says that I told her that I consented. So my point is if Ms. Wheatley can write that in her judgment, which led you to write that in your judgment, what's stopping Juan Wolf from putting that in his order, what he wanted to say? It's not what really happened. It's not what really happened in Wheatley's court. So what I'm saying, that if people are saying something in court and then you write the exact opposite of what they said, how's that not supposed to feel like a knife in your back? So you keep saying that that was consented to, but I can assure you, as God is my witness, that I did not consent to any order. The only order that I consented to was the one that actually I signed, which was in 2012. And the last order was not made in 2010, as you have also written. The last order was made in 2012. And it was a consent order, and my signature was required. There's signatures required on a consent order. Otherwise, you're just typing up a judgment saying what you wanted to say.
Thank you. Well, we'll retire for a while. Please wait whilst we do so.
Yeah. Keep it together, Wanda. Yeah. This is what they destroyed. Sorry. I fight for my family.
Are we all?
Good morning, my lord. If it pleases you, I know this is quite unusual, but I would ask the court a little discretion. I just wish to indicate a fact that this court may not be aware of, that Miss Pedro instituted a new claim which is presently in the Supreme Court for constitutional redress, and it includes a claim for misfeasance in public office. It's a concurrent claim currently filed. We have not yet had a directions hearing, and the Crown has not yet had an opportunity to make the appropriate application, but it may be relevant.
Again, I don't know what I'm doing as a litigant in person, so I just threw that in there, but I did institute constitutional proceedings, yes.
Okay. Is there a limitation period on constitutional proceedings? Mr.
No.
Kennedy?
There's absolutely none.
No, that's what I thought. No, that's what I thought. Okay. We don't propose to grant Ms. Pedro leave to appeal to the Privy Council because even if she had an appeal of right under Section 2(a) of the Appeals Act 1911, we are not satisfied that the proposed appeal raises a genuinely disputable issue. We will give short further reasons for that decision hereafter.
Great, my lord.
Right. Thank you very much. We will retire.
Thank you, and a very good day to you all.
Are we going to the retiring room?
Yes.
Yes.